legal pond.
Welcome to today's episode of the Legal Pod. Today's episode is going to be on duress and undue influence as vitiating factors of a contract. Let's get started.
The legal pond.
Welcome back. As I said early on, today we are looking at duress and undue influence as vitiating factors of a valid contract. What is duress? What is undue influence? Now let us pick them one after the other. Duress. Now, there is one thing about the law of contract that anytime the parties are entering into a contract, the law requires that the parties must have entered into the contract out of their own free will, out of their own desire. Because contract creates obligations for the parties, the law does not expect any person to be forced or coerced into entering into a contract. So that is why when someone is being forced to enter into a contract, the law sees that contract as an improper contract. So when a person enters into a contract by way of duress, that contract is not a proper contract. What is duress? Now, duress occurs when a person enters into a contract out of illegitimate threat or pressure or even coercion. So if we threaten someone to enter into a contract, if we give actual threat on a person to enter into a contract, or we put the person through coercion to enter into a contract, that is what we call duress. So if you point a gun at the head of a person that the person should sign a contract, then even though the person has signed the contract, because it was made out of duress, because the person was put under some kind of pressure, that particular contract is not a valid contract. Now, the effect of duress is that it renders the contract voidable and not void. Duress renders the contract voidable and not void, such that it is voidable at the convenience of the coerced party. So the party who claimed to have been forced to enter into the contract has the option to rescind the contract or affirm the contract. So duress does not render the contract void. Duress is a common law principle, but it does not render the contract void. It only renders it voidable. Now, to succeed under an action for duress, what are the things you must establish as a plaintiff? If you're a plaintiff and you are saying that you were made to enter into the contract by way of duress, then what are the things you must establish? One of them is that you must show that there was a real threat on you which was illegitimate. So the threat which was applied on you was illegitimate threat. What is an illegitimate threat? Now, when we say a threat is illegitimate, it means the threat that was applied on you was unlawful. It was wrong. So for instance, if I tell you that if you don't enter into this contract, I will shoot you. Now, shooting a person is illegal in nature. So if I threaten you with something that is illegal, it means I have put you under duress. But for instance, if I tell you that if you don't enter into this contract, I will not enter into that contract, meaning there are two contracts, I will only enter into one of them if you agree to enter into the other one. That one is a threat, but it is not an illegitimate threat. It is not a threat which is unlawful. If I tell you that if you don't enter into this contract, I am going to burn your shop, that is an illegitimate threat. So first thing you must establish is that the person put you through illegitimate direct threat. It can be that I was slapping you, giving you some slaps when you were signing the contract. That is duress, pressure, direct coercion. So when you look at a case like Kaufman versus Gerson, the defendant threatened the plaintiff that he should sign a particular contract, else he will prosecute the husband of the plaintiff for a crime he has committed somewhere. And that particular prosecution was a wrongful prosecution. So he threatened her for wrongful prosecution of her husband for her to enter into the contract. And that contract was held voidable on grounds of duress. You may also look at the case of Barton versus Armstrong, where the managing director of a company was forced to buy the shares of someone who owed shares in the company on grounds that if he did not sign that agreement to buy the shares and to pay some amount to him, he is going to be killed. That particular pressure which was applied on him to enter into the contract was an illegitimate pressure. Therefore, the contract was rendered voidable on grounds of duress. The second element you need to establish when claiming that you have entered into a contract on grounds of duress is that you must show that there was lack of reasonable alternative. So you must prove to the court that at the time the pressure was being applied on you, you didn't have any other option. You didn't have any other alternative than to submit to the contract. Once you're able to prove that, then it means you were under duress. So you look at a case like Hemans versus Kofi, for instance, where a man was detained for 3 weeks and then he was denied bail, even on medical grounds, and the police were asking him to sell his property to pay debt before he will be released. Because of that, the man sold his house at a very lower price. That contract to which he entered into as a result of the pressure, as a result of the duress, was rendered voidable. The third element you need to establish is that you must prove to the court that you were induced by the threat or the pressure. That is, you must prove to the court that the only reason why you entered into the contract was because of the threat or was because of the illegitimate pressure that was exerted on you. So if you had other reasons for entering into the contract aside the pressure that was laid on you, then you were not induced by the duress. So you must prove inducement. These are the three major things: illegitimate threat, you had no alternative option, and then you were induced by the illegitimate pressure. Now, Lord Scammer, in the case of Pile On and Others versus Lao Yulong, gave 4 questions that we need to ask ourselves when we want to determine whether there is actual duress. So the judge said that for the court to be convinced that you were under duress when you were entering into the contract, we must look out for 4 things. One is that whether the person who is alleging to have been coerced protested the duress. If you protested the duress, then it means you weren't induced. 2, whether the person had alternative course opened to him. Did you have other options? Could you have escaped it? If you had other options and you decided not to use those options, then it means you were not coerced. You were not induced by the duress. 3, whether the person had independent advice before entering into the contract. So the thing is that if at the time the pressure was laid on you, you had the opportunity to seek legal advice or any form of advice from any other person before entering into the contract. Once you sought for advice before you entered into the contract, then it means you did not enter into the contract because of the duress, but because of the advice. Therefore, you were not induced. The final thing is that the judge said for you to say that you were induced to enter into the contract by way of duress, you must prove to the court that right after entering into the contract, you took steps to avoid the contract or to set aside the contract. So if you never took steps afterwards, then it means you did not enter into the contract because of the duress. So these are the 4 things given by Lord Scammon in the case of Pile On and Others versus Lao Yulong. Now, as time went on, the court developed another form of duress known as economic duress. Now, economic duress arises where a party to a contract exerts what we call illegitimate economic pressure on the other party for that party to enter into contract. So mostly it arises when one party takes advantage of the economic weakness of the other party to force that party to enter into the contract. Sometimes too, it can be that because of the economic difficulties faced by one party, the other party tries to withhold the performance of a contract based on that difficulty. So when you look at a case like DNC Builders versus Rees, where a debtor told a company that he was owing that even though I owe you £482, I am going to give you £300. If you fail to take that £300, I have nothing more to give you. At that very moment in time, the company was approaching bankruptcy. So the debtor wanted to take advantage of that economic difficulty of the company. The court held that that particular contract was voidable on grounds of economic duress. When you look at a case like North Ocean Shipping Company Limited versus Undue Construction Company Limited, where a company has contracted with the other company for them to build them a ship, and then at a point in time when the dollar devalued, they asked them to pay extra 10% of the agreed amount of the contract before they will build it, else they are going to withhold performance. So they had to agree and pay. Now, afterwards, when they sought to rescind that contract that allowed them or that made them to pay the extra 10%, the courts upheld their claim and rendered the contract voidable on the grounds of economic duress. However, we should know that not every economic pressure would amount to economic duress, especially when the parties to the contract bargained at arm's length. So if in case the 2 parties who were bargaining had equal bargaining powers and one of them had no form of dominance over the other, then the court is most likely not to hold that the contract is vitiated by duress. So in the case of Pile On and Others versus Lao Yulong, Lord Kaman said that justice requires that men who have negotiated at arm's length be held to their bargains unless it can be shown that their consent was vitiated by fraud, mistake, or duress. So it follows that it is not any kind of economic pressure that will suffice for economic duress. Another thing that we also look at is that for us to be convinced that there was an economic duress, then the party who is claiming to have been misled must show that he had no alternative or option apart from entering that particular contract under the duress. So you may look at the case of Atlas Express Limited versus Kafco Limited. So these are the principles regarding duress and economic duress. The next thing we are looking at is undue influence. Now, undue influence is another form of vitiating factor which vitiates the validity of a contract. Now, undue influence arises where one party to a contract exerts such influence on the other party to affect the consent of that party to enter into the contract. So here, it does not apply actual force. So it doesn't qualify as duress because duress must come with force. But with undue influence, it is more of persuasion, pressure, or influence that is short of actual force. Now, the effect of undue influence is that it renders the contract voidable at the option of the party who has been unduly influenced. So what it means is that the party who has been unduly influenced has the right to rescind the contract or affirm the contract. So the contract will not be rendered void. However, if the party who has been unduly influenced wants to rescind the contract, then the law is that because undue influence is an equitable concept, all the maxims of equity shall apply. Therefore, if the party wants to rescind the contract because he has been unduly influenced, then that party must act within reasonable time, because you and I know very well that delay defeats equity. So when you look at a case like Alcard versus Skinner, where the plaintiff came back 5 years after she has been unduly influenced, the court did not allow her rescind the contract, even though there was undue influence. Now, with undue influence, it comes in two forms. We have what we call express undue influence and presumed undue influence. Now, with the express undue influence, it arises where the two parties who are dealing together do not have any special relationship, but then there is an actual form of dominance by one party over the other. In such a circumstance, the party who is claiming to have been unduly influenced bears the burden of proof to establish that the other party exercised an undue dominance over him. So when you look at a case like Mole versus Lofman, for instance, Mr. Mole was a very wealthy man who was sick, but then he was living with Mr. Lofman, who was a part of their religious group. And then Mr. Lofman was the one who controlled all the affairs, he controlled the mind, he controlled the decisions of Mr. Mole, who was sick at the time. And within that period, Mr. Mole made a lot of gifts to Mr. Lofman, which worth over £140,000. Now, after the death of Mr. Mole, the family came back to claim that Mr. Mole made all those gifts because he was unduly influenced by Mr. Lofman. He did not make those gifts out of his free will. He was unduly influenced because he was vulnerable at the time. And the court upheld those claims. Lofman exercised what you call express undue influence over Mr. Mole's life. He exercised actual dominance over Mr. Mole's life because he was the one controlling his decisions. Then we have presumed undue influence. Now, with presumed undue influence, it arises when a person is placed in a position that creates a fiduciary relationship between him and the other party. And such relationships comes with the duty of trust and confidence. So relationship like doctor-patient relationship, lawyer-client relationship. In such relationship, the law presumes that anytime these two parties enter into a contract, the stronger party has influence over the weaker party. So if you're a lawyer and you enter into a contract with your client, the law has already presumed that as a lawyer, you had an undue influence over the other party. You exercise dominance over the other party. Therefore, the duty is on the stronger party to prove that, one, the weaker party sought for private advice or independent advice before agreeing to enter into the contract. So when you look at Alcard and Skinner, for instance, where a lady joined a sisterhood and then she transferred her properties to the leader of the sisterhood during that period she was with them. Then later, she realized that she did not do all those transfers out of her own will. She came back. The court held that yes, there was an undue influence, a presumed one, because the sisterhood could not prove that the lady had independent advice before making those transfers of the property. However, the reason why the court did not allow the lady to claim back the property was because she waited for 5 years. So equity saw it as very unfair to allow her claim back after 5 years, especially when we know that delay defeats equity. You may also look at the case of Mercer versus Brempong II. So basically, these are the principles regarding duress and undue influence as vitiating factors of a valid contract. If you have any question, you may send it to the numbers running on the screen, or you may put it down at the comment section and then an address will be given to it accordingly. Also, I encourage you to get a copy of the Legal Companion and look at all the questions and answers relating to this topic. See you in our next video.
The Legal Pond.